32nd meeting of the Education, Children and Young People Committee in 2025. The first item on our agenda today is to decide whether to take agenda item 4 in private. Is that agreed? That is agreed. The next item of business is evidence on the Restraint and Seclusion in Schools Scotland Bill. And can I welcome to the meeting today our final panel on this bill: Daniel Johnson, MSP, Member in Charge; Ros Thompson, Head of the Non-Government Bill Unit; and Caroline Mayer, Solicitor, Scottish Parliament. Thank you all for joining us today. And just before I invite Daniel Johnson to make an opening statement, I'd just like to mention a visit to the Donaldson Trust that myself and other members of the committee undertook earlier this week. During the visit, we were able to see the Trust campus, meet practitioners and some of the people the Trust supports, and find out more about the approaches that they use to help neurodivergent people across education build life skills, develop independence and improve their well-being. And as part of our visit, we discussed proposed changes to the law around the use of restraint and seclusion. And it was certainly very interesting for those of us who were there to hear their views on the subject, with the team at the Trust highlighting the approach they take, focusing on well-being and de-escalation. And just formally on behalf of the committee, I've written to Donaldson's Trust, but I'd like to get on the record our grateful thanks to everyone that we met at Donaldson's for their help with our visit and also their contributions to their views on this bill. So having said that, I now invite Daniel Johnson to make an opening statement. Over to you, Mr Johnson.
Well, thank you very much. And actually, just before I open up, can I just also say I recently visited Donaldson's as well, and it's a really fascinating place and excellent work that they do. But look, can I begin by saying thank you, first of all, to the committee. I know this is a very busy committee and that you're looking at multiple bits of legislation. So I really do thank them for everyone for taking the time to look at my bill. I'd also like to thank the Scottish Government. This has been quite a long and engaged process, and I've had a number of meetings with the Cabinet Secretary, and that has been very constructive. But I would also like to thank the Non-Governmental Bills Unit. I really do think it can't be overemphasised what excellent work they do and what an excellent aspect of the Scottish Parliament they present. But look, just very briefly, because I really want to get into the questions. I think the first point is that this bill actually arrives at the end of a long process. Beth Morrison first brought a petition to the Scottish Parliament in 2015 that sought to restrict the use of restraint and seclusion. We then had the Children and Young Persons Commissioner producing an excellent report looking at the use of restraint and seclusion in schools, and particularly around data in 2018. There was a subsequent report by Enable in Safe Hands, which came to very similar conclusions. That resulted in a meeting with the government that produced a 5-point plan that sought urgent issuing of guidance in 2019, which then resulted in guidance being produced last year. And we have had guidance in 2011, which was then updated in 2017. But we should make clear that as part of that 2019 meeting, the EHRC wrote to the government stating that in their view that 2017 guidance was not compliant, and did bring forward the prospect of judicial review. So this isn't something that has just come about. This is part of a long process. And I think it's worth just highlighting what that Children and Young Person Commissioner report found. It found 2,674 instances of restraint. It found that only 18 local authorities were reporting, only 18, and not the same 18, were able to provide data. Only 13 of those 18 could actually provide numbers of children, and only 12 able to provide insights on its use with regard to additional support needs. So this is a situation that is affecting hundreds of children, and yet we don't have sufficient data, don't have sufficient clarity. So this is what my bill seeks to do, is provide guidance about how, what is ultimately, in any way that you seek to look at it, a very serious intervention that can occur at school, putting guidance on a statutory footing, so that has to be complied with. But importantly, also recording that so that we can understand the situation, informing parents or guardians, and having a reporting mechanism so that we can understand the use of restraint and seclusion at a national level. But over and above the legislation or the numbers, I think is a fundamental insight. I took the time to read every single one of the submissions to my consultation. And I have to say that was a very difficult thing to do, because when you read the testimony of people reporting what has happened to their child and the anguish they've gone through and the sheer frustration just to find out what has happened to their child at school, why they have come home with bruises, that often taking weeks, if not months, to find out precisely what happened. That's not something any parent would want anyone to go through. And also, ultimately, this. Everyone around this table who is a parent or has children in their extended family will be familiar with the little slips of paper that come home from school. That when a child grazes their knee after falling down the playground, has to be countersigned and handed back. That is the level of recording, reporting that is going on when things happen at school that are a matter of an accident. So why isn't it the case then when injuries happen as a result of deliberate intervention, the same things shouldn't have to happen? I think they should. And with that, I'm really happy to take questions.
Well, thank you very much for that opening statement, Mr Johnson. And maybe if I can just start there, because I have asked a number of our witnesses that very point that you've just ended on. Why do I, as a father of 2 young boys, constantly get updates that they've tripped in the playground, etc., but we have witnesses and written testimony in terms of our call for evidence, your call for evidence, saying that parents whose children have been restrained or secluded are never informed. They quite often know something has happened because their child's behaviour has changed significantly from going to school in the morning to coming home, but because of some of their own problems, they can't express that themselves. So for these children, it's even more important that this is recorded, reported and informed to the parents. Why is that not happening? In your deliberations over this bill, have you found any reason why that's not happening at the moment?
I really struggle to answer that question because I don't know and I don't really understand. Because I do think that these are very serious situations. I also take the view that schools act in loco parentis. That essentially there is a bond of trust between parents and schools. And I think parents trust that schools will tell them when things happen to their child. And I think given the level of recording and reporting and acknowledgement that we do require, I don't understand the argument that somehow that this is burdensome to be asking this when this is a result of direct intervention. I think the only thing that you can interpret, and you see this in some of the responses, is maybe an anxiety that the reporting deliberate action might result in further action. But I think that is actually an argument to put the guardrails in, put the clear processes in place. So actually that's not the case. So that I think we can all understand, especially with children with profound need, that there may well need to be the need to intervene physically. But I think what's important is that we're really very clear about how that happens, when that happens. And critically, because of the point that schools are acting in local parentis, it's really vital that parents are told. I mean, ultimately, schools are acting on behalf of parents, and therefore parents, I think, really have to be informed in as quickly as possible.
You also detail very well the history of getting to this point, and you called restraint and seclusion a very serious intervention. Why then, given how serious this is and how much history there is and the campaigning of Beth and Kate and others, has it taken this long for a member not in government to bring this forward? Do you believe we should have been here before now, and why are we here in 2025 and not years earlier?
Well, I mean, fundamentally, the reason I am bringing forward a Members' Bill, because I don't believe that we've seen the urgency of action that was called for back in 2019. I mean, I understand the complexities. I actually also understand some of the concerns about the burdens this might place on practitioners. But in the end of the day, this is a situation where we are talking, certainly in the more serious instances, things that in any other setting we would be considered assault, certainly a use of force. I think in any situation where organisations, and especially the state, are using those things, you need to have very, very careful consideration. And I am quite simply frustrated that we haven't seen more urgent action. And I certainly think that we need clear recording so we understand this. And that certainly needs to be on the basis of law. I think whenever someone's liberty is restrained, whenever someone is put in seclusion, whenever force is used about another individual, we need very, very careful scrutiny of that. And that's fundamentally what this boils down to. And I think we have had guidance now for well over a decade of one sort or another. It's time to have that on the statutory footing.
So just explain to the committee and those watching, what do you think would be the material changes for children, young people, their families, if your bill passes, that are not being delivered at the moment?
In a word, clarity. I think that we can all understand that while we would wish instances such as these to be avoided, they will occur. But when they do occur, I think it's really important, first of all, from a parental perspective, that they are informed and informed promptly so that they understand. They don't have to piece together what has happened to their child. They don't have to try to figure out why a bruise has occurred. That actually, more than retrospectively, that they probably have some clarity about the sorts of things that will be going on at school and that might form part of their child's care. But I think as a country, I think we also need clarity in terms of the pattern of how this is occurring and what circumstances, and that we have some oversight. But I actually also think for practitioners as well. At the moment, because of a lack of statutory guidance, and especially when you look at the guidance, and I think there's been some criticism of the current guidance from some quarters about the lack of kind of practical help it provides, I think it's really important that if there are situations where practitioners do need to use restraint or seclusion, that they really have clarity about when that is appropriate to do so, and critically, what form that takes and that being appropriate. That's why the training element. So all of those things are essentially all boiled down to clarity. Clarity for the individuals, for the parents, for practitioners, but also for all of us as a whole as a country.
So just on that clarity in terms of the number of instances that occur, I had a discussion with the Cabinet Secretary when she was in front of us on this bill about how that should be reported, public or otherwise. And there is some unease, I think, within local authorities and perhaps COSLA that will end up with league tables and this school or this local authority uses restraint far more. What's your view? Because on one hand, we want to be as open and as transparent as possible. On the other hand, how will people use these figures if they are publicly available?
Well, first of all, my bill isn't prescriptive at precisely how these will be reported. Importantly, it's important to point out that in terms of collection, that will be at local authority level, that local authorities would then be required to provide that to Scottish ministers, and it would be up to Scottish ministers how that data would be provided. Sorry?
Do you have a personal view on this?
I mean, I do believe that should be reported at a local authority level. I think reporting in more detail than that, I think, is problematic for two reasons. One is, I don't think you would want that school-by-school information for exactly the reasons that have been outlined. And also, I mean, I'm hoping that actually the numbers either would be or would become small. And I think if you report at school level, you'd really run the risk of jigsaw identification. And I think that, and particularly, particularly thinking about certain school settings where there may be actually small numbers of children or young people attending, I really think that would be a concern. But I think what it would do is allow issues to be identified at that local authority level. I think would allow further questions to be asked, both by ministers and by parliamentarians. So I think, first of all, just that acknowledgement that this is you would not provide the level of detail that would provide, certainly in terms of the collection that would allow league tables. It would be a matter for the government to decide precisely how to do that. I think the other thing I would just want to highlight at this point, and I'm sure we'll get into definitions, is that, I think it would be, as the bill stands at the moment, it enables the definitions to be elaborated upon, and therefore precision and perhaps some categorisation of different types of intervention and that data being collected in that way. But I'd also reflect that I'm certainly very open to tightening up the definition, especially around the reporting requirements to make that more precise.
Okay, we will get into some of these other issues, but just finally from me, you've got government support, which must be very welcome as the member in charge for this bill at stage 1. But there is opposition to it. There have been concerns raised, particularly from the teaching unions. What do you say to those unions watching you today who are concerned about this bill and what it would mean for teachers, classroom assistants and others within the school setting?
Yeah. So I understand their concerns. I understand the pressures on the teaching profession overall. I understand the pressures actually on all practitioners that work in the classroom. But I do find myself struggling somewhat with some of those arguments, and for two prime reasons. First of all, it is contended that the guidance is already being followed, and if so, I don't understand why putting the guidance on a statutory footing is therefore problematic. If the guidance is being followed, and I don't foresee there being kind of a huge change in the substance of the guidance, I think it would be revised, but I don't think it would be altogether different. I therefore don't understand why putting the guidance on the statutory footing it would be problematic. Secondly, it also does flow from a more fundamental point. And I outlined this in my previous answers, is that we are talking about the use of force, the deprivation of liberty. And when those things are occurring, I think they are very serious. And therefore, we need the most robust levels of oversight and recording. And I think that anyone who states that that's not the case, I really ask them to explain why they think that should just be a matter of routine and shouldn't require what I think is, not a terribly onerous level of oversight. Really, what we're just asking for is that these things be recorded. I've not specified precisely how. That may be simply a matter of recording in an electronic journal. I've not specified how the informing should occur. That's probably, in most instances, just a phone call. And in terms of the training requirements, I think it's very understandable if physical intervention is going to be applied, especially that's foreseeable and regular. Clearly, people need to have training. I have not heard an explanation why any one of those elements is problematic.
Okay, thank you very much. We'll move now to Pam Duncan-Glancy.
Convener, good morning to Daniel Johnson. Thank you for answering the question so far, and also for your passion and commitment to this particular issue. I know that there are many young people and parents and carers across the country that take this very, very seriously, and will be grateful for the committee's attention on this, which of course you have occasioned. We've heard through the debates around restraint and seclusion in relation to disabled pupils, pupils with complex needs or care experienced pupils. In the member's view, is the bill equally applicable across all settings, and should there be additional protections for disabled pupils, pupils with complex needs or care experienced pupils?
I think the member's raising a really interesting point, and in a sense goes to heart of the matter. I think the most profound concern probably does come from those people with those sorts of needs. Whether it needs particular provision, I'm not clear. Primarily because I think when you actually look at kind of the bulk of these instances, we are talking about children with additional support needs, i.e. it would be impossible, I think, to look at this guidance, look at this area of practice without having additional support needs absolutely front and centre, because they are. If you look at the current guidance, they very much are. But I also think it's also interesting from another perspective, and perhaps it'd be interesting informally to follow up with members of the committee that visited Donaldson's. When you actually talk to people working in settings such as those practitioners have the least issue or concern, because they understand the need for the sensitivity in this area. In fact, certainly when I spoke to people at Donaldson's, they almost questioned the need for it because they didn't use these sorts of restrictive practices. So I think that absolutely that the development of the guidance, I think when we look at this bill, we must have additional support needs and young people with disabilities at the forefront of our minds. Whether it needs more specific provision within the bill, I don't think so, but I'm obviously, that is precisely what I have in my focus.
Thank you for that. And I think it's often said that sometimes if we get it right for those particular children, then you can lift others at the same time. And I think that's the approach the member is setting out. Throughout the committee evidence as well, we heard quite a lot from third sector organisations. Are you in a position to set out the sort of engagement that you've had with third sector organisations and where you see their role in including the guidance and also in implementation?
It's difficult to set that out because that engagement has been so extensive. I mean, I have had a huge amount of engagement with organisations such as Enable, National Autistic Society of Scotland. I mentioned I've been up to Donaldson's. Children First, Children's Scotland. I mean, a huge number and at various stages and in various forms. I think what they... I don't think it can be overstated how important those organisations have been in terms of actually shining a light on this topic. I think in terms of actually bringing to light both what is happening in our schools, the sorts of practices that are sometimes employed, and kind of the need for action. I mean, frankly, we wouldn't be here without their engagement and their diligent work. And I think they will provide a really important role because, again, and as the convener pointed out, there's a number of children who are impacted by these practices who are not able to express themselves, who are perhaps non-verbal, or certainly if they are verbal, or don't have kind of the full range of expression. And therefore, organisations that are able to provide advocacy and provide insight, I think, are really important. And so they provide an invaluable role, and my engagement with them has been extensive, both throughout this, but I mean, as members are probably aware, I mean, I sat on this committee in the last Parliament, and so my engagement that really stems back to the very start of my time in this place in 2016.
And have they suggested any changes to you, to the bill, or have they encouraged you to look at any different approaches during the next passage,
yes,
the next stage of the passage?
So if there's been criticism from that quarter, is that those organisations would typically like me to go further and do more, to have an increased scope, to also look at other areas. I think, both in terms of when you look at the complexity of law that we have around additional support needs, we have a real kind of complex web of different bits of legislation. Probably starting with the 1980 Education Act, extending through to the Additional Support Needs Act and beyond. I think, so first of all, I really recognise there's a real need to perhaps provide some clarity about how the different rights that are embodied in those acts, but also recourse. If I had time and resource, absolutely an education bill that resolved that would be something that I think would have a lot of merit. I think likewise, in terms of scope, there's a lot of merit in looking at the other contexts that young people find themselves in, whether that might be transport or overnight accommodation, other contexts where young people find themselves in the care of people other than their parents or guardians or carers. But quite simply, this is a member's bill. I have to have a kind of quite clear scope. The complexity of doing that just would require a level of resource that's not available to me. But I think that there is an election next year. I think that a new government should very seriously look at those things. Okay, thank you. Thank you, Convener.
Thank you. George Adam.
Convener, good morning, Daniel. I was just asking a question with regard. You mentioned the teachers. You said that you understood the difficulties and challenges that they deal with in a classroom environment. But many of them have been saying, when does seclusion become seclusion after a child has been disruptive in class, and they're saying it's classroom management. So, when does... They say your bill doesn't actually make that difference, to make it clear to them. and it's a challenging environment. It's on the moment. It's when things are happening in the classroom. So how can you make them feel better about that with regards to your bill?
So, first of all, let's be very clear about what the definitions do and don't do, and what they. I don't think it would be appropriate to put that level of specificity on the face of the bill. The definitions are there to provide a scope of behaviours within which we must have guidance. And it's for the guidance, I think, to really provide that level of clarity about when seclusion is seclusion and when it's not. But let's also be clear about what the definition does specify. That's about actually putting a child in a space separate from other children, and in such a way that they don't have the choice as to whether or not to stay in that space. I think that makes that relatively clear. That's not just about a child being brought to the front of the class or put to the corner. That is about putting them in a separate room from which they cannot remove themselves, and that is separated from other children. I think that's maybe not kind of natural language, but I think it is pretty clear. Now, I think as a matter of practice, the guidance does need to then, I think, start zooming in and narrowing in it, not just in terms of how that decision gets made, but also actually the appropriate form of that. Because let's also be very clear, what that would mean, I think, is quite serious. I mean, if that was to happen to any of us, placed in a room that you could not remove yourself and separate from other people, I think that's quite clear. That would be a deprivation of liberty. And what is more, we know that this is something that is going on. I mean, when you look at the various reports that the various organisations that have provided, there are children that have found themselves on more than one occasion put in cupboards and in such a way that they cannot remove themselves. So, does the wording on the face bill provide absolute precision? No, it doesn't. Nor should it. That is a matter of guidance. And absolutely, I'd expect that guidance. But let's also be clear, what is specified in the bill is something that I think we would all agree is quite a serious situation.
So how does the bill kind of support teachers to make sure that they are aware of what they can do and what they can't do in this scenario? Because it's still a major concern. I think we just received some details from EIS with regards to your bill recently as well. So how do you get that to them, that they feel secure that they're in a safe place to still be able to manage their class?
So again, let's be very clear about what the bill is and is not doing, what the definitions do and do not do. The definitions are just simply about providing the scope of practice around which there needs to be guidance from the government. It's not saying that anything is prohibited. It's not providing any penalties. It is literally saying that when there are actions being taken that fall within this scope, the government must then provide guidance. And I think then for the guidance to provide the sort of clarity that the member is seeking for, and quite rightly so. And I think that is a very normal way for this place to proceed. In fact, I mean, I know Jackie Dunbar is here. We were having a very similar discussion yesterday at the Assisted Dying Bill. I think there was a balance between actually the boundaries that we create in legislation and the things that then we leave as a matter of practice. So what we are saying is that here is a scope of activities that we think need to be regulated by guidance, and is then for the guidance to specify precisely what those look like.
Okay, thank you, Gavina.
And we now move to Jackie Dunbar.
You scared me a little bit there, Mr Johnson. I wondered what you were going to come away with.
Apologies for that.
Can I first of all, Convener, add my thanks to the Donaldson Trust for facilitating our visit on Monday. I found it to be very, very informative. And can I just say a special thanks to the amazing young people that spoke to me, and I found them to be absolutely brilliant. Mr Johnson, the current Scottish Government's non-statutory guidance was published just last November, and at the session we had with the Cabinet Secretary recently, she said that the Scottish Government's plans to review the impact of that the Scottish Government plans to review the impact of that guidance so far. Given that we currently don't know how effective the current guidance is, because it's not had a review, do you think the timing of the bill is appropriate, or do you think it... I do realise that we're getting very short on time to the end of session, but do you think it's right to do it now or not?
I do. I know when the guidance came out, on the one hand, it has now been out for over a year. I think actually it is more than possible to actually have a look at what its effect has been, but it doesn't stand in isolation. It is not, is not the case that there has been no guidance before the issuing of that guidance. There was guidance in 2011 and then 2017. But I think most critically for me is the guidance might have only been out for a year, but this is a topic that has been being discussed in this place for over a decade. There was a commitment to urgent action in 2019. So if the guidance hasn't been out sufficiently long before us contemplating, I think that is a question for the government rather than one for me. I think 2019, that's 5 years ago, there was a commitment to having rent guidance, and 5 years ago it was also observed that would likely need statutory underpinnings. And I really think that kind of a whole Parliament on from that, if now isn't the time to legislate, when will be? And genuinely, if I'm doing anything, yes, perhaps I'm slightly forcing the pace, but I worry that if I didn't do that, nothing further would happen.
My question, yeah, I understand what you're saying. I think my question was that will we get everything right in the bill if the guidance hasn't been reviewed before we start putting things in place for the bill? Maybe that was what I was trying to get out.
No, I think it's really, and that's a pertinent question. And actually, in some ways, it relates to what I was saying to George Adam. I think if this was a bill that was putting lots of detail on the face of it, then I would agree, or I might agree with some of those concerns. But it doesn't. Nor does it specify a timeline for the government to produce guidance on the basis of this bill. It just says that states that it would need to, and then make sure that guidance is updated. So I actually think, in terms of timing, it doesn't do that, and nor does it in terms of reflections. It doesn't preclude reflection, doesn't preempt any reflections. It actually just requires the government, as a matter of law, in order to undertake those reflections. But I think the other key point is around data here. I mean, one of the issues is we still actually don't know the prevalence of some of this. And again, apologies for restating this point. I mean, I do really think some of what we're talking about is some of the most serious things that I think that can occur within a school setting. And I think without that data and without that kind of consistency of that data, it's kind of hard to have those reflections. So it doesn't preempt those reflections, but more importantly, I think in order to iterate this, and this will be a matter of iteration and updated, I don't believe that we're going to have guidance that is going to be produced and will be immutable, forever and all time. But in order to have that kind of iteration of guidance and updating, we need data.
Okay, thank you. Thank you, Convener.
Thank you. Ross Greer.
Thank you, Convener. Good morning. I'm interested that this follows up somewhat on George Adams' line of questioning around some of the concerns that the government expressed in their memorandum on the bill, particularly around definitions, because I think it's fair to say that that was also an issue that quite a lot of the witnesses we've taken evidence from have struggled with. So the government's concerns you'll be familiar with are a very broad definition, could capture things like holding on to a child's hand to cross the road safely, or some of the support that would be required for children with particularly complex needs. There's always a challenge between how much detail you put on the face of a bill versus what you leave to regulation versus what you leave to guidance. So in the first instance, I'd be keen to hear your response to the concerns that the government have raised around definition on the face of the bill.
Yeah, I'm going to come back to the holding hand point, because actually I would contend that doesn't constitute restraint on the basis of the definition. But I think it's an important point. Look, I think, first of all, just reiterate the point. If we actually look at what the definitions do, it's literally just about providing scope. There are no prohibitions, there's no prescriptions. It's literally about providing scope. I think the second point I'd make is that the definitions are very much in line with the guidance that was produced by the government in 2024. So it is compatible with what the government has already produced. In fact, I would argue actually it's narrower. If you read that document in its entirety, in some places in the government guidance at the moment, it also includes providing that restraint can be physical actions that constitute supporting a child. Now, the definition on the face of the bill is narrow on that. The one point I think where I think there is, I think I really need to look at it, and I think it's a point that the government has made both to me in private, but also in terms of the correspondence and oral evidence they've given you, is actually how this then relates to reporting. As well, what I just said in terms of providing a kind of a scope for the guidance, and then the guidance can then further refine its focus. As it stands, it may be too expansive for reporting. So, I mean, I'm very open both to narrowing the definitions with regard to guidance, if that would be helpful, but in particular, providing further clarification on the face of the bill in terms of reporting requirements. And I think very much focusing on the more sustained uses of physical intervention, where a practitioner is using physical intervention over a sustained period of time, perhaps over minutes rather than seconds, for example, and that being the basis of reporting. But then just finally, I would just like to make a point. This isn't about defining all physical contact as restraint. It certainly does not do that. This is about physical intervention that actually deprives an individual's ability to act independently. That's why I'm not sure that holding a child's hand, I mean, normally when you're just holding a child's hand, they can withdraw. It's maybe when that is more forcible. I think the other set of circumstances are, when a child maybe, I think most importantly for me actually is, a supportive hand on the shoulder, perhaps even a hug from a teacher to a child, especially for younger children. Those, in my view, that's not restraint, that's physical communication. But then there's a final category around kind of interventions that perhaps protect the child. I think this is the sort of the example of the pushing the child out the way of a moving vehicle example that's been made to me. And I think we do need to look at that. And I think that's why, perhaps looking at that duration, and I think, or what have you, maybe in order. But I think there's also another way of looking at this. If those things are happening, if it was my child that was on a school trip and had to be pushed out of the way of moving bus, would I want to be told about that? Yes, I would. Would I want that to be recorded and reflected upon about how that happened? Yes, I would. So again, sometimes, yes, I understand there are nuances here, but I actually do think overall we do need these things captured and reflected upon as well.
Yeah. I'm reflecting on, you remember last session, also a member's bill on equal protection. A lot of the same suggestions were made at that point, particularly around the point of holding a child's hand or pulling them out the way of a moving vehicle if they jumped onto the road. Same arguments were made. So far as I'm aware, I don't think any parent has been prosecuted for pulling their child out the way of a moving vehicle. That being said, though, I think some of the really granular points you're getting into there, distinguishing between, for example, holding on to a child for seconds versus minutes, ongoing restraint, etc. That all makes complete sense, but it immediately strikes me as a level of detail that would be impossible on the face of the bill.
Yes.
Very much has to be in the guidance. But that gets back to the point about this kind of core argument about whether taking the statutory approach of the bill is necessary versus the fact that the guidance already exists in this space, and the concern that some of the witnesses have expressed, particularly teachers, around this fear that there will be something in the law, but what's in the law is not going to be specific enough for them to know what they should and should not do, because that will be held separately in the guidance, etc. I just wonder if you could maybe talk a little bit more about how we provide absolute clarity and confidence to particularly teachers and other school staff in this case, that they will be able to, that they will be compliant with the law, even if there is quite a difference between what's in statute versus guidance that is produced as a result of it.
So let's be really clear about what the bill is doing. I mean, again, there is no prohibitions, there's no offences being created by these definitions. In terms of compliance law for individual teachers, there's actually nothing in the bill around individual teacher compliance. This is for schools and local authorities to oversee. So this is not, absolutely is not the case that teachers will, on an individual basis, be facing these questions. These are questions for both school leaders and for local authorities. Secondly, again, and apologies if I'm repeating myself, this is a fairly typical way to legislate, is that you create scope and then you provide detail within guidance. And particularly, my bill makes particular provision allowing those definitions to be elaborated. And I know there's concern even about the use of that word, but let's be clear what we're talking about. This is not about expanding on. This is about refining and specifying and clarifying. And I think it is important that the guidance is clear, because ultimately that is the appropriate place for that practical advice, so that actual teachers do have clarity about what's appropriate and not. But let's also just bring this back to the fundamental. If force is being used by one individual against another individual, depriving them of their ability to, that is very serious, and that requires, I think, real clarity about how and when that is permissible. And really, all the bill does is state that the government has to provide that clarity and guidance.
Thanks very much. I think that's all from me, Convener. Thank you.
Thank you. Willie Rennie.
I mean, this comes to the nub of it, doesn't it? I mean, the guidance is already there, so there should be all the clarity that we're looking for. What we're talking about here is putting it on a statutory footing. And we've seen with previous pieces of legislation that sometimes if you put something on a statutory footing, there is mission creep, there is over-caution. People go further to prove the point in order to make sure that they are covered and that they're not flouting the legislation. Is there not a danger here that we're actually going to make people much more cautious at critical moments when actually intervention is required because of that fear, and therefore you get mission creep? So it's not the actual recording, it's not what the guidance says about what's appropriate in terms of restraint, it's that extra caution that comes from it that actually might endanger children.
So I think this is an important point, and I understand the point. I actually think the current situation makes that worse. I think that having non-statutory guidance that I think doesn't have the precision that we might want, might not have the clarity, actually creates the ambiguity that leads to that situation. I think by having this on a statutory basis, requiring that clarity, requiring that engagement around definitions and indeed recording, I think will better promote a point where we actually have, I think, clearer definitions about what we actually mean by restraint and the appropriate responses. And critically, I think this is also why there's the training element. If this was just a bill putting this on a statutory footing without the other elements to it, particularly without the training elements, I might agree. But I think the key point here is that we're not just seeking to provide a document. This is also about actually providing clarity around training and practice itself. So this is always going to be an ongoing effort. But I don't actually think per se that the statutory basis or otherwise is. I think the moment the government is producing guidance, the concern comes along the lines Mr. Rennie points out. I think by making that guidance clearer and more precise, we minimise that risk.
But we're not talking about, I mean, yes, training, if you're specifying that that is required, then that should improve the clarity over, so individuals who are in practice should have greater understanding. But you're not given any greater clarity about what's permitted in terms of practice and what's not, because the guidance is established. So all you're talking about is moving that guidance onto a statutory footing. So there is no more clarity in that space from this bill. Isn't that the case?
By definition, perhaps not. But by process, by actually requiring the government to maintain this, I would hope that look. In the end of the day, I can't legislate, for the government to provide good guidance. I mean, I wish I could, but I can't. Nor do I think it would be appropriate to try and provide that level of clarity on the face of a bill. Again, I just don't think that is sensible. But what I can do is try to ensure that that guidance, first of all, is being consistently applied, and that's a really important element of the statutory footing. Secondly, that is sort of maintained and updated and reviewed. Again, without it being in the statutory footing, there's no compulsion on the government to ever produce guidance ever again in this topic. I think some of the other additional points, I think the recording and reporting elements, I think, are useful, not just so that we all gain kind of clarity. I also think that forces a requirement to look at precision. Because I think what Mr Rennie is talking about is that, and we're familiar with it, is if when things are vague, that's when you get speculation almost sort of regulating things rather than actual clarity. I'm doing everything I can to improve that clarity. And at the moment, I would argue that it's that lack of clarity that's leading to the situation that Mr Rennie has concerns about.
So the second point is around about the GTCS.
Yes.
You'll have heard
yes.
that they're saying almost this is piecemeal, that we need to have perhaps a broader look in the whole safeguarding child protection area, because currently most of that is on a kind of a guidance basis rather than a statutory footing.
Yeah.
What's your answer to that?
So first of all, I think Mr Rennie might be putting words in the GTCS's mouth slightly with the word piecemeal. I think they recognise, the value of this. I think they think it's very specific, I think is the word I would use rather than piecemeal. But they're absolutely right. I mean, I think there's a much wider question here, and I alluded to this in earlier answers, about the wider context around safeguarding, around the wider legislation regarding additional support needs, the rights that individuals have and recourses, because I think that is all really complicated. There's quite a broad range of different acts that all allude to this area, and I think that needs to be looked at. But that is far, and as I've sort of had in my discussions with them, and they acknowledge the point here, that sort of effort, as necessary as I think it is far beyond the scope of what can be undertaken by a Members' Bill.
Just for clarity, as Mr Johnson knows, I've been a supporter of the bill, but I think it's important to ask difficult questions. So
I would expect nothing less of Mr Rennie.
Thanks very much.
Bill Kidd.
And thank you very much, Mr Johnson and team. Just to say that I was one of the people who was also on the Donaldson visit there on Monday, and it really was genuinely interesting and very worthwhile being there. And we did speak to staff about similar aspects as is covered in your bill here, actually, and they were aware of what was coming forward. However, you get nothing for nothing, and the Donaldson facility is a terrific place, but it's not dirt cheap or anything like that sort of thing, so there are costs to everything. So can I ask what interaction you've had with the Scottish Government on issues raised in the memorandum, such as implementation costs of the bill? I mean, variations on what we already is established as the cost of education for bringing young people through. Are there variations on implementation of the costs that you can see forward?
Yeah. So I may bring Ros Thompson in just to cover off the detail of the methodology of the financial memorandum. But just to step through that, I mean, first of all, I have met with the Scottish Government probably about every 6 months through this process. It's been a very extensive level of engagement. I thought it's been very important that they are aware of it, especially given the concurrence with their own issuing of guidance. And critically, and as I said directly to the Cabinet Secretary, it was really important for me that there was no surprises for the government in this bill, and that's the approach I've sought to take, and therefore, as I understand it, the government sort of broadly agrees with the numbers set out in the financial memorandum. The costs are not overly significant. Mr. Kidd's absolutely correct. It doesn't come for nothing, but we're looking at sort of a year one cost of approximately £3 million, and then ongoing costs of this similar figure. Against the context of the education budget, that is not the hugest amount of money. And let's also be clear: we have guidance. We have all actors saying that guidance is being complied with. I don't envisage a huge alterations to the guidance being required. So the implementation does take account of the need to revise and reissue that guidance. It does take account of some additional implementation costs, but we are also taking a face value from people, both providers and the government, that essentially compliance with what is there is taking place. But Ros, perhaps you might want to provide some clarity about the more detailed elements of the methodology.
Thank you. So the financial memorandum is drafted by the NGBU, and it begins with context, so the current resourcing arrangement. So there's the member asked for inclusion of things like underfunding of presumption of mainstream education and other resource limitations in the education setting. So obviously that's extremely relevant context for the committee. For the purposes of drafting a best estimate in the financial memorandum of the costs, it just addresses things that are directly introduced by the bill. There are no estimates in relation to things where the Scottish Government has said that work is already underway. For example, the introduction of a data set for some of the data that's required under the bill. Also, in relation to training standards, there's work already underway from a working group in the government. But it costs everything else as far as it can. Obviously, the biggest cost is implementation in schools, be it special schools, mainstream schools, or units attached to mainstream schools. And in the absence of the baseline data that Mr Johnson referred to, it is impossible to estimate where each school is at in terms of how much, the extent to which they've implemented the guidance that already exists, and therefore assess how much money is required in order to fully implement the provisions of the bill. So what the financial memorandum does is takes a blanket approach and works on estimates of days required on a recurring basis to continue to implement the provisions of the bill. And it does that on the basis of teacher salary. But there is flexibility in relation to how that funding is used. So it might be that a combination of different levels of staff is used in the implementation of the bill. And on a recurring basis, it might be that schools or education authorities might choose to use that funding for things like training, freeing up staff, or any of the other putting in place reporting requirement processes, any of the other requirements of the bill. So that's the basic approach taken.
Sure. And is it the case then that the Scottish Government, because we have background, that the Scottish Government, as you said, Mr Johnson, has been working in this general direction anyway, so are they comfortable with any changes financially because they were heading in that direction?
I mean, that is my understanding, and just to reiterate, and not just, when I sort of set out that pattern of engagement, that's my direct engagement. There's also been an engagement between the NGBU and officials. Yeah. So and indeed, the Scottish Government, in terms of directly, is saying that it notes that education authorities are currently meeting the costs associated with restraint training that's required by the current guidance, and that these, and also acknowledge that these costs have been acknowledged in the financial memorandum. So, in a sense, they note our approach and seem to agree with its broad approach.
So I'd be comfortable with that anyway. Okay, well, look, thank you very much indeed. That's useful. Thank you.
Just because you mentioned a few times there about your engagement with the Scottish Government, have they always been in favour of this bill and supportive?
I'm very glad that they're being as supportive as they are now.
Mm-hmm. I mean, I normally say to people that's a politician's answer, but I suppose from a politician that's allowed. But the point I'm trying to get at, sorry, Mr Johnson, the point I was trying to get at, because from my own bill, there is an opportunity for the government. There's a period that the government can take on a non-government bill if they are supportive. Was there discussion then that the government could take this over from you?
Yes. And I think there was discussion actually from both directions. Being perfectly candid. So I think the government had looked at whether or not there were ways that it could legislate and incorporate this within other legislation. I also, and actually for many of the points I kind of that have been kind of asked about, in terms of especially Willie Rennie's question about GTCS and about those broader points, from my perspective, I sort of feel that in some ways this might have been better as a government bill, as part of a more comprehensive package. So I'd been very open to the government taking this off my hands, so to speak, and taking it forward as legislation. But I think, as we're all aware, that as we've sort of gone on through this Parliament, that this legislative programme has become, I think, more congested. But that was part of the discussions. I think there would have been merit in this perhaps being a government bill. I also think there's merit in it being a members' bill, about just sort of making sure that we're keeping pace. And I think that the key point, just to sort of explain my politician's previous answer, is I think fundamentally the government has been of the view that there needs to be guidance in this area, there needs to be clarity in this area, frankly there needs to be improvement in this area. I think for all the reasons from, in terms of some of the voices that we've heard described, they had been wary of confronting those and therefore had been ambiguous as to whether or not they wanted to put this on a stretch. But the guidance being on a stretchy footing had been part of the dialogue really throughout the period of time that I outlined in my introductory remarks. So hopefully that sort of provides some context, both in terms of kind of the dialogue, but also kind of how, where I view this could and should be in terms of a members' bill or a government bill.
No, it does. That's helpful context. Thank you. Paul McLennan.
Thanks, Mr Johnson. We've heard evidence, obviously, about different policy frameworks across different services, such as schools, obviously care settings, as well, in terms of, and childcare providers, about, obviously, use of restraint and seclusion. Does the bill risk dual reporting in some settings, for example, schools with ALC classes, or around about residential facilities? Because we heard, obviously, from schools with residential facilities. So it's just around about that reporting kind of issue, around about that. What your thoughts are on that?
Yeah. So I think it's a really important point here, and I've deliberately drawn a narrow scope. So the first point is, I think this does need to be context specific. I don't think it's really possible to provide a sort of single set of guidance around all possible settings. I think particularly when you're looking at age range, and I think there's been some calls regarding whether or not this could or should apply to early year settings. I think for practical reasons, I think that becomes really complicated. I think the level of physical interaction you need to provide, the youngest children is just, on a common sense level, we all know that it's very, very different. Yeah. I think similarly, both in terms of interaction with pre-existing law, but also in terms of again, the context, providing a kind of single set of guidance that covers both education settings and care settings, transport, I think is really complex. In my view, I don't think this would require double reporting. And I think that the government is also of the view that at the very least that if there is, that can be resolved through kind of clarification and so on. But I understand the point here. But I think from my perspective, this is about actually providing kind of clarity within a school's setting. I think to provide something that's more comprehensive, again, would be, I think, really beyond the scope of what would be achievable or manageable within a member's bill.
Do you, where do you, I know it's kind of moving out with the discussion about the bill, but where do you kind of see that then? Because if we're looking at the bill and there's that area, as you said, kind of almost out with the scope, kind of, where do you see that kind of area falling into in terms of what happens next, isn't it? Because obviously we have evidence from residential schools and so on, but where do you kind of see, because we're looking at the scope of the bill, but I suppose perhaps sound more clear in terms of that area that you've deliberately not widened the scope to, where do you kind of see that kind of going? Because it's what's in the bill, what's not in the bill, and that's obviously things that we should be looking at. Where do you kind of see that area developing?
So, again, I think it's incumbent on the government to look at all of these things in the round. I mean, I think there are, even removing my bill out of scope. I mean, if you look at some of these settings, whether it's residential schools or early year settings, they have multiple layers of oversight. Yeah. Full stop. I mean, my bill doesn't alter that. Likewise, residential schools will have to have a relationship with the local authority. Again, my bill doesn't alter that. I mean, I think there is a need to have a look at how these different things interact. I mean, frankly, I think even there's a question about scope of some of these bodies. I mean, again, having sat on this committee in the last parliamentary session, again, thinking about early years, you've got the SSSC and the Care Inspectorate, both with a view, and again, also local authorities. I think we do need to think about that. I think, so I think in terms of the scope of what we're requiring, I don't think this will require any additional or dual reporting, because it is about essentially the regulating of school settings. I think that's clear when a school setting is a school setting, and those bodies will already have those relationships. I think the wider point is an important one. I think it needs to be addressed. I just simply don't think it would be sensible for me to attempt to do that in this bill.
Okay, thanks, Mr. Justin. Thanks, Camilla.
Okay, move to Miles Briggs.
Thank you, Convener. Good morning, Mr. Johnson, and your officials as well. And just to start, I think you should be congratulated for the bill. I know as an Edinburgh MSP, we've dealt with similar constituents or the same constituents who have really highlighted their concerns. And I think that's very important that this is making progress, so congratulate you on that. I wanted to ask two specific questions, and it's returning to an earlier point in relation to informing parents and carers, and it's been put to us in terms of the approach of the bill requiring that information to be provided and what sort of timescale that should be, especially if there's welfare concerns around informing parents and carers, and just wondered what consideration you'd given to that at this stage.
So, I mean, this is clearly a topic that would require to be the detail of guidance. I think there are a whole raft of considerations around the intimation that an incident has occurred to parents, guardians or carers. Again, I think that is quite rightly a function of guidance rather than putting on the face of the bill. Quite simply, what I want to do is ensure that happened, and without question, and that's what the bill does. I also note that there's been sort of questions about whether 24 hours is too long. I think it would be perfectly within the gift of the guidance to specify a shorter period than that. I can't quite come up with an example, but I think there are circumstances, and I think particularly maybe more around the recording of the incident rather than necessarily the informing element, but there may be required a period of reflection or pulling together all the perspectives in order to do the recording, and therefore I thought a 24-hour period was appropriate. But yes, I mean, I think there is going to be context. I think also other considerations that are properly a function of guidance than I would expect to see there, and certainly not the sort of thing that you can put on the face of a bill.
Yeah, thanks for that. And then the guidance aspect is what you see as the main route then.
Yes.
For that, yeah. The committee, and I've raised this with on a number of occasions when we've been taking evidence, but it's been interesting to see how the Care Inspectorate and some of the reduction we've seen in restraint, and that is maybe around the conversation which your bill has taken forward. But the Care Inspectorate can provide support and challenge to care settings shortly after a report of restraint is made. And so I wondered, in drafting the bill, how do you consider a role for HMIE in providing that going forward and that support? And do you see them as having that proactive role?
Yes, and indeed, I mean, in fact, that is a feature of the bill that we would. I think there would need to be consideration by HMIE about how restraint and seclusion form part of its inspection regime. I mean, again, I wouldn't want to over-specify that, but I mean, my view is always the case that any sort of regulator or provider of oversight is there to provide support and encourage good practice as well as to stop bad practice. So, I think that as you outlined there, the Care Inspectorate's role in terms of reducing restraint in care settings is a good example of what we would hope to see in terms of kind of the overall regime. And again, I think that there is a question there. I wouldn't want to specify precisely how, but clearly I think that inspectors should be asking about these topics. I think particularly in settings where that might be more likely as well.
And do you see that proactively taking place? So, we know many schools haven't been inspected over a long period of time. And so with this specific piece of legislation, if we are seeing the reporting of incidents, and you've suggested that would be council-wide, not school-specific, but where there's a proactive piece of work then to take place. And I'm not sure leaving it to be part of a wider school inspection would necessarily provide that live support to address incidents and to address potential training needs, etc.
So first of all, let me be very clear. In terms of that reporting and the publication, yes, that would be collated by local authorities, specified at that level. The data would clearly exist at a school level. So in terms of inspection regimes, and I think members are absolutely right to flag the sort of the changing nature of that regime and the fact that some schools go for quite long periods of time between inspections. However, what we do know is that the inspection regime is meant to be responsive. So when concerns are raised, that there can be inspections on the basis of that. And on that basis, and we're into the realms of speculation here, but I mean, what I would hope is that in conjunction with the guidance and the reporting regime and kind of some consideration by the inspectorate as to kind of how they should do this, that we would see this forming part of an inspection regime, but potentially if there are specific concerns that you see the inspectorate reflect and be able to engage on that basis. But I think that is sort of slightly into the realms of speculation as to where this might end up. But absolutely, I think that could and probably should be a proper part of the role that the inspectorate sees for itself.
Yeah, thank you. Thanks for that.
Just on Mr Briggs's first question about the recording and reporting, we have had one submission in our call for evidence that suggests it could perhaps be the next school day. Would you agree with me that that risks leaving children and families without any information over a weekend if it happened on a Friday, or indeed over weeks and up to months if it happened on the final day before the summer holidays, before they return for the autumn term?
Yes, I think I might put it a bit more strongly than that. I just think that would be inappropriate. I mean, 24 hours for very good reason. I think if you're a parent, I think the very latest you'd want to know is the next day. And I think your parental responsibilities certainly span the weekend. The consequences of an incident like that may well actually be very germane over a period of time, because it may well be result in that child being very distressed and unable to articulate why they're distressed. So therefore, knowing that has occurred, I think the very longest period of time a parent should have to wait is 24 hours. And as I sort of was intimating in my previous answer, I think that may actually, in some cases, be too long in itself. I think that's the very longest I would want a parent to have.
So do you not then think we need to tighten that up, that it should be the day it happens, it's reported, and if it takes 24 hours to record that in some way, perhaps that's acceptable? Because you could have an incident that happens at 3 o'clock on a Thursday. They then have until 3 o'clock Friday, but that's still an overnight for that child's gone home. Yeah. Should it not actually be tighter to say the same day it happens, parents must be informed, and then if the reporting takes 24 hours, the full details are within the 24 hours?
I think that argument has a lot of merit. I think it's quite compelling. I think my key question is whether or not that level of detail is more appropriate for the guidance, or whether, what I wouldn't want to do is introduce, for complexity or difficulties when that might not be possible, or, for example, a parent just can't be reached. They don't pick up their phone before the end of the school day, for example. So it's just, to my mind, there's just a small hesitation about whether or not that being on the face of the bill is appropriate. But absolutely, as a matter of practice, I think what the convener's just set out, what you've just set out, convener, is absolutely, as a matter of practice, the way things should be.
Okay, thank you. John Mason.
Thanks very much. I mean, just on that point, should we be aiming then at, say, either 24 hours or the end of the school day, but there would be room for some exceptions?
Yes.
Because, I mean, it has been raised that, some parents might react badly if the child had been in trouble. Yeah.
Yeah.
Okay. To move on, we've touched on some of these issues already, but especially on reporting, if we can just kind of pin that down a bit, because I mean, it seems to me there's three main options. A school reports to the local authority where the children came from, which may or may not be the local authority where the school is, or to the local authority where the school is, or just purely at a national level. And am I right in saying you're leaning towards reporting to the local authority where the school is?
Yes, but I mean, this is sort of in a level of detail that would require to be resolved. I know the government is engaging on this point as well, but I mean, I think this is as a matter of sort of regulation, i.e., this is about where it's not, rather than it sort of necessarily being the local authority. This is actually strictly and formally speaking about the education authority, i.e., which council is actually, in a sense, acting as that education authority for that school in that area. And therefore, I think where the school is situated is more appropriate. But there is going to be, I mean, I think I understand the alternative point of view, but I think that's the most appropriate way to do it and the simplest way to do it.
Although if it's an independent or grant-aided school, it would not at the moment have much of a relationship with the local authority where it's located, would it?
I think most do at some level. It's a different relationship, but they will be engaging with their local education authority.
Mm-hmm. I mean, I think we got the impression at Donaldson's on Monday that because the various local authorities, especially I think in the east of Scotland, are paying for and sending young people to them, primarily their relationship is back to that original authority. But as a
funder, and I think the other thing to add is I think the government is looking at whether or not it would actually report those as a subset of the information, just in order that we don't end up confusing the data for those reasons, just because they do have a very different relationship with local authorities, full stop. Because even the one that the member is setting out there, I mean, essentially, the local authorities have a very different. They're literally using them as a provider of education rather than sitting as a sort of a regulator of that institution as a provider of education, if that makes sense.
Yeah, I mean, it just struck me that, and I think it was touched on earlier by the convener, that if there was a problem in a particular school, but they're reporting to 10 different local authorities because the kids come from 10 different places, it might be difficult to pick up there was a problem in that school. Yeah. And whereas if they're reporting to the local authority where they are, and maybe it has to be both, then they might pick up there was a kind of bigger problem.
So I think that's exactly why there needs to be national reporting. It's also why the bill isn't like overly specific about precise that. I mean, this is a matter for the government ultimately to resolve. They will be, it's for local authorities to collect. It's then for the Scottish ministers to then determine how to report on that. And I think this is into the level of detail that they would need to resolve. But I think as I understand it, the suggestion is that those schools would be reported separately in reporting. So in a sense, what we're asking that the local authorities do is literally just collate that information. We may simply just be asking them to be clear about just be clear about the nature of each of those schools and where those schools are of the type that Mr Mason has just identified.
I mean, I think I take your point that that's a level of detail we might not want to see in the bill. I think it is an issue that has concerned some of the grant-aided and independent schools, so they've been kind of raising it with us. To move on then to the whole question of training, again, that's been touched on a little bit already, but the idea of this list of training providers, again, that has created something of a response. And, for example, would councils who do a lot of in-house training still be able to do that, or do they have to go to an external provider?
I mean, the short answer is no, and the reason for that is that what the bill doesn't say is that every single teacher must receive training. It is up to the Education Authority to identify what number of practitioners require specific training. It's also not true. It's also, as alluded to, not the case that no training is currently taking place. What I think it is important, I think especially for training of kind of perhaps the most sort of serious kind, for practitioners who are very likely to need to use physical restraint and on a regular basis, it's really important that actually we maintain some sort of regulation as to what that training looks like and consists of and who it's being provided by. I mean, one of the issues we have right now, there are providers out there at the moment providing training that's based on stress holds techniques derived in adult contexts, if I can put it like that, that in my view are wholly inappropriate to be used in schools. So therefore, what the bill has sought to do is, in a relatively light touch way, just enable, in essence, something of a Scottish Government kite mark, just saying, look, these are the sorts of training courses. For the people that need that sort of training, these are the sorts of courses that are appropriate. These are the sorts of providers that are appropriate. In essence, I don't believe it actually requires a huge amount more than currently occurs. So at the moment, the government signpost to the restraint reduction network, I would just like to see that go a little bit further. But that's not to preclude that for some, and for probably most practitioners, training that is provided by local authorities may well be appropriate. Again, train the trainer. But again, this is for the guidance to start pulling apart those categories. But to be clear, what the legislation I think really is important that we do for that use of physical restraint. I think it is really important that we regulate that.
And just the physical restraint, or also the de-escalation that might prevent it? Because that was a big emphasis we had from some of the witnesses we had, and also at Donaldson's. I mean, Donaldson seemed to have gone to in a sense, the other extreme of saying we will not use physical restraint, and it's all about de-escalation. But the fact they've got 2 adults for every pupil does kind of help that.
So, and I think the point around de-escalation is a really interesting one. And I've seen all the written submissions sort of questioning why that hasn't sort of featured specifically on the bill. I mean, first of all, it is absolutely embedded and informs the direction of travel in this bill. I think in terms of, I think there's also a question of, I want to future-proof this legislation. You can, de-escalation is sort of current terminology, doesn't have a basis in law, and critically, I mean, I think, we're all familiar in this place, the terminology will probably have moved on in 10 years' time. But to be clear, I mean, the focus for me is around that physical intervention. I mean, I think the consequences of getting it wrong, in terms of using de-escalation techniques are of a different order of magnitude in terms of getting it wrong if you're using physical restraint. I mean, that's very much the target that I have in my
But if you don't get the de-escalation right, you're more likely to get into a physical situation, aren't you?
But that's why that doesn't exist on its own. So first of all, it's for the guidance to set out good practice. It's also for the guidance to set out kind of at what point you would need to use the training provided. The training providers. That's not saying that's the only training that would be available that would help people dealing with these situations.
Should that training be coming into teacher training right at the beginning?
In broad terms, yes. I mean, I've taken the view for a very long time that initial teacher education should have a much more explicit focus on additional support needs. I think within that, I think that needs to have real clarity around, I think, elements of cognition, executive function, and then by extension, de-escalation. And I think that is absolutely, I think that's should be a core topic for anyone embarking on a teaching career.
Now, if I heard you correctly, you said that it would be the local authority or the education authority that would decide what training different teachers needed. The Cabinet Secretary, as a teacher, seemed to suggest that each individual teacher should decide what they need. And presumably the middle ground would be the head teacher decides what all of their staff need. Have you thoughts around that?
I mean, what is set out in the bill is that it's for education authorities to determine.
Mm-hmm. I mean, it's going to vary quite a lot, isn't it? Because, I mean, you've got specialist schools. I mean, Donaldson's, again, gold standard or whatever you want to say. And then you've got special needs schools. But you've also got mainstream schools where we end up with two kids hitting each other or a kid hitting a teacher. So, I mean, any teacher in any school could end up in a kind of confrontation where there's a need for physical intervention. So that would imply that every teacher needs training in this field.
I'll bring Ros Thompson in a moment on that. I don't think it does. I mean, I think what the bill sets out is that when that is likely and providing training for those people that are likely to need to use it as a result of that context. Now, Mr Mason's absolutely right. That will vary by context, but that's also why it's really important that we have local authorities taking a lead on that. But that's not to say that every incident of physical interaction is restraint. Certainly with two children fighting, I mean, if a teacher needs to intervene, perhaps, but if it's just on a one-off basis, that is different. But let's also be clear what, again, the target of this is. This is about ensuring that when practitioners are using force on a prolonged basis to restrict a child's freedom of movement and liberty, i.e., using holds, this is more than just separating. That absolutely does need training. Now, that's not to say that there should be thought quite the reverse. There needs to be detailed thought about how do teachers intervene, how do they separate. Does that need the same level of training as somebody who may well need to use particular forms of physical intervention? I don't think it does. It is an area where I think that there would need to be, some clarity and nuance and teasing apart within the guidance. But the focus of training, why that is because we're talking about the most very serious physical interventions that absolutely could and frankly do result in children being injured, and that's what we need to try and minimise, if not prevent. But I'll bring Ros Thompson in.
Just briefly to add to that, the education authority level sort of understanding of training need, I think it's envisaged that the evidence from Ben Higgins that you received from the Restraint Reduction Network talked about training needs analysis on a school-by-school level, because, as you say, schools differ enormously in function, and so that would inform the extent to which lower level de-escalation technique training, perhaps trainer within schools could be used. But in terms of anything in relation to training on restraint, the Scottish Government guidance already states at paragraph 113, where restraint is a foreseeable possibility, schools should use restraint training that is certified as complying with Restraint Reduction Network training standards. So to an extent, those standards are already established by the government. So the training provisions within the bill absolutely would be seeking to exist with existing provisions.
Right. I mean, we had the suggestion that, in fact, some teachers currently, because they're unsure what they can and cannot do, hold back and do not get involved in situations where they maybe feel they should. And that by giving training on kind of physical techniques and some of that kind of thing, that might actually encourage them to get more involved physically. So we could see an increase of physical interventions.
I think this boils down to the need for clarity. I think in either way, I think people not intervening when they should is not necessarily something that one would want, nor would overuse of that, which is why I think that it's really important that if it's likely, and especially in a context with children with additional support needs, that those people that are likely to need that do absolutely have, I think, a level of training over and above what we might normally expect. But I think what we also need is clarity about what is and is not appropriate. And I think if there is ambiguity, I think that's where the danger lies.
Okay, thanks so much. Thanks, Convener.
Convener. Earlier, when we were having our interaction earlier on, we kind of touched on the wider issues in schools and the impact that that's having. And Daniel Johnson will be aware of some of the people who have been a bit worried about the bill in terms of resources and the implications that that could have for schools. And I note that in the policy memorandum, the member is alive to the issues, and I don't doubt that particularly from what we've heard on the record this morning. There are a number of people who say that a lack of resource could contribute to the unnecessary use of restraint and seclusion in schools in Scotland, particularly given rising behaviour concerns. Can I ask the member what his response to that is?
Yeah, so I respond to it in a number of different ways. In essence, I don't think my bill alters that. I think if these things are occurring, I think we want to know about them. If people are making physical interventions, that we want that to be on the basis of I think being informed correctly and also trained appropriately. And in a sense, there's a tension here for me. Is I almost don't know who to believe. On the one hand, I'm being told that we're already, everyone's already complying with the guidance, and if so, I'm kind of going, well, great. So what's the issue with putting it on a statutory basis? And on the other hand, people are telling me this is going to have massive resource implications, which would then go, well, I thought you said everyone was complying, and you can't have it. You can't have both going on. I think, but most fundamentally, let's also be clear. I think that there are different cohorts and different dynamics going on here. And overall, when you're looking at education policy, you have to look at everything all at once. But what I am looking at here is about typically, quite often children with additional support needs, quite often of primary school age, and quite profound need. I think the wider issues around behaviour in schools and violence in schools, I think it's a much bigger topic. It extends through the age ranges. And I think that's reflected, the evidence that we've had from, education. I think that's quite clear from Lynn Binney's contributions as well. So, look, and I think ultimately, just because there are other issues and problems, and indeed ones that are even connected, doesn't mean that we should do nothing. I think this is something that actually can provide clarity, will provide support, and indeed training to practitioners that really need that, and ultimately also about actually providing clarity for parents. And again, The other response I have to this is that, especially on that point, it is a different situation with the violence. But again, as a parent, if my child is involved in an altercation at school, I'd want to know. I'd want to know if they were at the receiving end of that. I'd want to know if they were actually the instigator of that. And if that had involved the teacher, I'd want to know. I'd also want schools to have a clear understanding of those situations and what they're doing and have a clear plan to do it. I don't think my bill detracts from that. I think actually it might even help with that.
Thank you. Much appreciated, Convener. That's all from me. Thank you.
Thank you. And that's all the questions from the committee. Is there anything, Mr Johnson, you want to get on the record ahead of our Stage 1 report?
No, look, can I just thank you. Hopefully I've provided all the answers you need. Please come back to me if there's any further clarification that you require. But above all else, I just want to repeat what I said at the beginning. Just thank you very much for taking the time. I know you were very busy at the moment. This has been a kind of a pretty extended endeavour for me, so I just really appreciate you all taking the time and effort to look at my bill. Thank you very much.
And we appreciate your time, your answers today, and indeed from the Non-Government Bills Unit and the Parliament team. So thank you to you and the officials who've been represented here today. That concludes also the public part of our proceedings. We're going to move into private session, so I'm going to suspend the meeting to allow our witnesses to leave and the committee to move into private. Thank you.